Good afternoon. On behalf of the Greater Philadelphia chapter of the Association of Corporate Counsel and my firm, Saul Ewing, Arnstein and Lair, thank you for joining us today for our webinar presentation on an overview of force majeure provisions and related litigation in the COVID-19 era. We've been a proud sponsor of the ACCGP for many years and appreciate the relationships we've made with all of you. Now, I have a couple of reminders for you on behalf of the chapter. The Business Skills CLE Institute is scheduled for October 22nd, and the Corporate and Security CLE Institute will be held on October 28th and 29th. You can find more details on both of those scheduled events on the ACCGP website. Now, before we begin, I'd like to review the roadmap for the next hour or so. So first, we'll start with some introductions and housekeeping matters. We'll move into an explanation of force majeure, what it is and why it's relevant today. We'll then talk about the applicability of force majeure, as well as some litigation and practical considerations. Then we'll talk about other relevant doctrines that operate in a manner that's similar to force majeure. And finally, we'll end with a review of some recent cases that have been filed in the context of COVID-19. My name is Jared Hawk, and I'm a partner in the firm's Pittsburgh office and also lead the firm's force majeure litigation team. Now, I'm a trial lawyer and I represent clients in litigation across the country. My practice is primarily focused on representing product designers, manufacturers, and sellers in product liability litigation, parties in complex commercial transactions, and oil and gas exploration and production companies in energy litigation. I'm joined today by my colleague, Kira Smerkanich, who is located in our Washington, D.C. office. In addition to being a member of the force majeure litigation team, Kira is also an active member of the firm's insurance industry group. In this capacity, she represents carriers and brokers in coverage actions and other complex civil litigation matters. Now, Kira and I would like to thank the Philadelphia chapter of the Association of Corporate Counsel for the opportunity to speak with you today. A couple of housekeeping matters. You'll notice at the bottom of your screen, there's a Q&A function. Questions can be submitted through the Q&A tool at the bottom of the screen. We'll do our best to answer the questions within the time we have allotted for the webinar. But additionally, we'll invite you to join us for an informal Zoom meeting immediately after the program so that we can ditch the chat tool and actually have a conversation around your questions and concerns, which is something we just can't do in a webinar. So please feel free to join us in our post-webinar Zoom meeting. The meeting ID and passcode is on your screen, and we'll show it again at the end of the presentation.
Jared, we actually got a question in already about, are the slides available?
Sure, thank you, Kira. Yes, we will make the slides available, and we will actually send out an email at the end of the presentation that will contain the slides. So as far as CLE credit, today's program has been approved for continuing legal education credit in Pennsylvania and New Jersey. In order to verify your participation and receive your certificate of attendance, you'll need to provide a brief CLE survey and note the random numeric codes that we'll provide during the webinar. There'll be 2 of them and we'll announce them verbally. The survey link that was in your webinar reminder, and we'll post it again in the Q&A box as well for your convenience. Please be sure to complete the survey within the next 5 days. As far as materials, as I said, we'll provide those in a thank you email that we will send at the end of the webinar. Now, finally, no presentation by a group of litigators will be complete without a disclaimer. So here goes. The provision and receipt of the information in this presentation is not legal advice. It does not create a lawyer-client relationship, and it should not be acted upon without seeking professional counsel who have been informed of the specific facts. And with that, let's begin. Next slide, please. So I want to talk a little bit about our firm and what we have done to address force majeure issues. As you see in the screen, we have created 2 teams of attorneys that can assist with these issues. The first is our state COVID response team that tracks orders and guidelines in the relevant jurisdictions as they are issued. And why is that important? Well, when you're dealing with COVID-19 in particular, many of the force majeure events that you are going to be relying on will likely be based on these state government orders. And we have a team of lawyers across our footprint that has been tracking those orders. And again, that's something that you can rely on when invoking force majeure. And the second team I want to tell you about is a team I've already mentioned. It's the force majeure litigation team. It's a multidisciplinary team of litigators across our footprint. And our goal has been to study and track litigation trends involving force majeure. And there's a nice image of the various team members and the jurisdictions in which they practice and which their offices are located. Next slide, please. So what exactly is force majeure? It's a contract provision that excuses or suspends a party's performance obligation. It's a French term that means superior force. So as a contract provision, obviously force majeure must be invoked contractually. It is not a common law doctrine. You either have it in your contract or you don't. And if your contract doesn't have a force majeure provision, then we're not going to be talking about force majeure with respect to that particular contract. Luckily, force majeure provisions are included in many contracts across the board. These are purchase and sale agreements, contracts for the provision of goods and services. I do a lot of work in the oil and gas arena. Most oil and gas leases that I've seen over the years all include a force majeure provision. And the only problem is they're included in a lot of contracts, but a lot of times they're treated as boilerplate. The parties don't put much effort into drafting them. A lot of times they will just be copied from a prior contract. And there's not a lot of thought that goes into the process of, if I actually need to invoke force majeure, is this provision actually going to cover my needs as a party to this contract? So the one thing that I would ask that you take away from this more than anything is the ability to invoke force majeure and whether it's going to apply is really going to be determined on a case-by-case basis. And there are three things that are going to affect that analysis. The first is the language of the contract. As I said before, some contracts don't even have a force majeure provision. Some do, but it could be much narrower than a party would maybe like it to be. The other issue that you need to consider is the law of the jurisdiction that will govern the dispute. Each force majeure provision, well, force majeure in general, are going to be guided by the jurisdiction and the laws of that jurisdiction. So each jurisdiction treats it differently. You've got to know where your contract dispute is going to be, because that will affect the force majeure analysis as well. And then finally, the specific facts of the case. You can have the best force majeure provision in the best jurisdiction from a legal perspective, but if you don't have the facts to back it up, that's going to be problematic for you. And so all three of these issues combined are going to affect whether force majeure can be invoked and whether you're going to be successful in invoking it. So next slide, please. So why is it relevant today? Was everybody knows, I'm guessing most of you are viewing this webinar from home. COVID-19 has turned the world upside down. And there are many things that we're talking about nowadays that a year ago we never thought we'd be considering. And that's where force majeure comes into play. So some examples on the screen: supply chain issues. As many likely know, this virus originated in China. Many of our clients likely have contracts with companies in China to provide goods or services. And when the virus originated there, China was the first place to get shut down. So you start to see the backlog starting in China. You then move into travel restrictions. Companies can't travel to China. When it starts to migrate to other countries in the world, there are travel restrictions put into place there. If you can't travel, there's a good chance then you may not be able to fulfill certain obligations under a contract. More extreme provisions that we've seen started in the spring of this year. Your stay-at-home orders, your shutdown of certain non-essential businesses. Obviously, those types of government orders are going to affect a party's ability to perform under a contract. You even, in certain instances in the United States at least, have seen the closure of certain facilities due to employee exposure to the virus. I recall seeing a number of meat packaging facilities that had to shut down for a certain amount of time because a certain percentage, up to a third of their workforce, had tested positive for the virus. Obviously, that's going to impact contractual obligations. And then you have prohibitions against certain groups gathering of certain sizes of people and social distancing requirements. So that is going to affect things like concerts, conferences, weddings, just a number of ways that this virus has affected a party's ability to perform under contracts. So given all of these events, parties have started to look at their contracts saying, number one, do I have concerns about my own ability to perform? And number two, do I have concerns about my counterparty's ability to perform under the contract? Next slide, please. So when a party sits down and says, I need to think about whether force majeure is going to apply, what do you do? The very first thing you should do is you need to consider why force majeure may need to be invoked. And what I mean by that is identify the event that is causing the issues with contractual performance. Is it the virus itself? We've seen a number of cases where a party may just have said COVID-19 is the force majeure event. I think that's problematic because it isn't necessarily the virus that's doing it. It's the tangential effects of the virus, the government orders, the shutdowns, travel restrictions, things like that. So look and try to, at the outset, specifically identify the event that is causing a party to have problems with performing under the contract. But you also have to look at it not just in a vacuum, but as a whole. Are there other events that could have also had an influence on contractual performance? Was the performance of the contract at risk before this force majeure event occurred? And are there other confounding factors that could have affected contractual performance? So after you've identified the force majeure event, next you need to look at the contract to see if the contract covers that. So next slide, please. So most force majeure provisions are going to have a number of these elements that we have listed on the screen. The first is a list of specific events that constitute force majeure events under the contract. Things like acts of God, extreme weather conditions, labor strikes, things of that nature. So you'll have your list of specifically enumerated events typically. Some force majeure provisions will have a catch-all language at the end. Sometimes that is going to be enforceable. Other times, depending on the jurisdiction you're in, it may not be. Some force majeure provisions may have an explicit foreseeability requirement in it, in that the force majeure event cannot be foreseeable or was not a foreseeable event to the parties when they drafted the contract. Some force majeure provisions will have notice requirements requiring you to, before invoking force majeure, give a certain amount of notice to the other side. And sometimes they'll be very specific in how you do that. I've seen some contracts that say verbal notice by the end of the day, followed up by written notice within 3 business days. The important thing is if there is a notice provision in the contract that you follow it. Some contracts will have mitigation obligations with respect to force majeure, and will say something to the effect that even if you have a force majeure event, you have to do whatever you can to either mitigate damages or attempt some kind of partial performance if possible. And finally, some force majeure provisions, again, read in conjunction with the remaining provisions in the contract, will dictate what happens in the event of a force majeure event. Does it simply mean that performance is suspended? while the force majeure event is occurring and until it subsides, or can the force majeure event actually lead to the complete termination of the contract? Again, as I said before, this catch-all language, we don't know, and it depends on the jurisdiction you're in, whether that's going to be enough. If your force majeure event that you are trying to use is not specifically enumerated, and different jurisdictions look at that differently. The best practices that you can do right now is to look at how your particular jurisdiction has handled these types of events in the past. And quite frankly, from tracking this for the last 6 months, there's not a lot of case law out there that talks about force majeure in the context of a pandemic. So you have to find similar situations and do your best guess as to how a court will handle that. Next slide, please. So on the screen are 2 examples of force majeure clauses that we've seen throughout our journey in this over the last several months. The first is a relatively short force majeure provision. And again, the yellow highlighted language shows the specifically enumerated events. And again, if we're looking at this provision in the context of COVID-19, you may have some issues with this, because a pandemic or a government shutdown or any government order aren't really specifically enumerated here. But again, you deal with what language you have in the contract and you make the best of it. The next provision, the second one listed there, is more extensive. And again, you'll see that it specifically notes epidemics. The one other provision or event that I would recommend that you look for are government orders or regulations or things to that effect. That is where we're seeing a lot of the litigation going. Next slide, please.
Hey, Jared. So we got another question in asking, what does Pennsylvania or the Third Circuit say about the catch-all language? And I know Pennsylvania tends to be a little bit more restrictive in looking at just the items listed, and is a little more restrictive in the catch-all language, but wanted to see if we could provide some more details on that as well.
Yeah, Pennsylvania courts have held in the past that when you're dealing with catch-all language like that, it can work, but the event that you are trying to invoke with the catch-all language has to be of the same kind of category as the prior events. So they're going to take those specifically enumerated events in the contract, and they're going to use that as the lens with which to look through whatever event you're trying to pull in through the catch-all. So can you get something in under the catch-all if you don't have a specifically enumerated event? Yes, but it can be difficult. And again, it's going to be looked at through that same lens of the previous enumerated events in the contract. So some drafting tips in light of what we've just discussed. And the very first is avoid what I talked about in the beginning. Don't treat force majeure provisions as simply boilerplate. Think about your position in the particular contract and your industry. If you are the party to the contract that all your obligation is to pay money for goods or services, then you probably either don't want to have a force majeure provision or you want to have a very restrictive one. Whereas if you are going to be the party that actually has to perform under the contract by producing widgets or performing a certain way, you need to maybe think about having a more robust force majeure provision. Again, think about the list of events that you're including in the contract carefully. Are they the types of activities that make sense given your industry, given the contracted issue? And so keep that in mind as you go. One other thing you might want to think about is think about how you phrase those particular events. And for example, we have on here terrorist acts versus threats of terrorism. If you have a contract that has a force majeure event that is simply terrorist acts, and you have before a concert performance somebody call in a bomb threat and the performance is canceled, there's a pretty good argument that you haven't had a terrorist act because it was never consummated. It never actually happened. whereas a threat of terrorism is going to have the same effect as a terrorist act. It shuts down the venue, but that kind of language, you have a little bit more wiggle room as far as arguments go. And then with respect to the catch-all language, again, it's not going to be bulletproof, especially depending on which jurisdiction you're in, but try to make it as broad as you can. And, any event similar or dissimilar to the foregoing, that tries to at least contractually get around the Pennsylvania issue that I just talked about, or any other reason whatsoever beyond the control of the party. Again, very broad language, and depending on your position in the contract, you may or may not want that type of language. So next slide, please. So as I said before, force majeure is a contractual provision. You have to raise it contractually. And what makes that important is it also works in tandem with the other provisions in the contract. And so there are a number of provisions that you should be looking for when you're doing this force majeure analysis, other than just the force majeure provision. The first is your dispute resolution provision. This type of provision will specify the timing and the steps that will need to be taken to resolve the dispute. Some of them require a party to provide specific notice of a default. Sometimes they will include a right to cure within a certain amount of time. Others will specifically enumerate the type of procedures that you have to go through to try to resolve it. I've seen some where the first step is negotiation between executives of the two companies. You'll next see some third-party mediation or other type of non-binding alternative dispute resolution. Obviously, you want to make sure whether your contract has an arbitration provision in it, because obviously that's going to affect whether you have the right to run into court or not, or whether you are going to have to proceed in arbitration. Choice of law, jurisdiction, venue. Obviously, as I've said before, one of the three things that is going to affect any force majeure analysis is the jurisdiction's law that's going to be applied to the dispute. So you need to, number one, know about that so you can make an educated decision as to whether to invoke force majeure or conversely fight a force majeure invocation. Also know where you need to resolve the dispute. So it may be very specific, as in, state court in Pennsylvania, or it could be even more specific and could say, state court in Allegheny County, Pennsylvania, or Philadelphia County, Pennsylvania. So again, the contracts a lot of times will specifically state those types of issues so that you will know where the dispute's going to be resolved and what law is going to apply. Time is of the essence. This is an important one with respect to force majeure, as we'll see later in one of our case discussions. This requires that the contractual obligations be strictly performed in accordance with the time periods that are actually set forth in the contract. And courts will strictly construe these types of provisions and hold parties' feet to the fire when they try to evade their contractual obligations as far as timing goes. Termination. A lot of times a termination provision will work in tandem with a force majeure provision. Sometimes force majeure will be adequate to terminate the contract. Other times it will not be. So again, check your termination provision. Material adverse change. This is a provision you'll find in some contracts, especially M&A agreements, that will permit cancellation of the contract if an adverse change significantly threatens the fundamental agreement in some sort of material way. So it's not force majeure, but it operates in a lot of the same ways as force majeure. So again, it's another contractual provision to look for. And then finally, limitation of damages or liquidated damages. A lot of contracts will come right out and say, if there is a breach, here is what the parties have agreed the damages are going to be. That can have an effect on the force majeure analysis. The other thing that's not up on the screen too, but fee shifting provisions. A lot of contracts will specifically say that the prevailing party gets attorney's fees. So that can really affect the analysis as to whether you want to litigate something, because you have to recall that if we lose this, we may be on the hook for the other side's attorney's fees in litigating the matter as well. So next slide, please. So some practical considerations with a litigation twist to them as well. The first and foremost is always consider any kind of non-contractual commercial solutions. You know, you should be engaging with your suppliers and customers proactively in a helpful and cooperative manner, while at the same time reserving all of your rights pursuant to the contract. And doing so can result in a more efficient and sometimes more successful resolution of the matter. And especially in the environment that we're in right now, parties are on both sides of contracts are struggling. These are business partners. You hopefully want to do business with this company again, so keep that in mind. You may be on the other side of the coin with respect to a different contract. So whatever you can do while still reserving all your rights under the contract and not doing anything to undermine them, to resolve something on a commercial basis may be the best way to go. The other thing that you should do is consider the effect of invoking force majeure in contract A, what effect that may have in contracts B, C, D, and E. You know, there are certain contracts such as bank loans or assets purchase agreements, where when you're invoking force majeure, you could render representations or warranties that you made to other parties in that contract or other contracts no longer true. So think about how that would affect it. Also think about how your argument as to one contract could be flipped on you with respect to another contract. Post-invocation obligations. Obviously, in most jurisdictions, most parties are going to have a duty to mitigate damages under either the contract or the common law. So obviously keep that in mind. Determine the effect of force majeure. Is it temporary suspension of the contract or the obligation to perform under the contract, or does it work to completely terminate the contract? And the other thing, and you know, as a litigator, I will tell you the one thing more than anything that you should be doing throughout all of this process is preserving relevant evidence and trying to avoid creating any harmful evidence. So the evidence that you want to think about preserving, any documentation of performance history before the force majeure event, all communications with the opposing party regarding performance, both before and after the force majeure event, and any efforts to perform under the contract. Again, you have this duty to mitigate damages. You want to be able to show that we tried and we weren't able to do so. And then as far as avoiding harmful evidence, the one thing I'll tell you is try to engage counsel as early on in the process as you can. And try to instruct employees to avoid taking inconsistent or harmful positions. You know, it takes one email from some middle manager saying, you know, we knew we never were going to be able to perform under this contract to sink a force majeure analysis or a force majeure case. So just keep that in mind. Try to get an attorney involved so you can hopefully protect communications regarding performance under the attorney-client privilege. But just have your employees be very careful in any communications they have, not just to the other side, but also internally, especially communications that wouldn't be protected by the privilege. So next slide, please. So we've talked already a lot about force majeure, and I'm going to turn it over to Kira soon to talk about some other relevant doctrines. So again, I said before, there are certain circumstances where your contract doesn't have a force majeure provision, or you have one and it's not very good. That doesn't mean it's the end of the day. And that is because we have these other doctrines that operate in ways that are very similar to force majeure. And Kira is going to discuss all of them. The first is for contracts regarding the sale of goods, you have this UCC section 2615 that essentially is a commercial impracticability provision. You then have common law impracticability and impossibility of performance, a similar but somewhat different doctrine called frustration of purpose. and then the old trusty illegality or against public policy arguments. So I'll turn it over to Kira, but before I do, I'll note on the screen is displayed the first CLE code for you to write down, and that code is 49185. Again, that is 49185. And with that, I will turn it over to Kira.
Thanks, Jared. And just really to sort of drive home the point that you made earlier, that a lot of these common law defenses and even statutory defenses as well are so jurisdictional dependent. So it's sort of, on your checklist, one of the first things you want to do is check the jurisdiction you're in and check what the relevant law is. And, an example of that is I am presenting today from Washington, D.C., which actually, separate and apart from force majeure clauses, recognizes an act of God defense. So if we were talking about D.C., which I understand we're in the greater Philadelphia area today, that's another common law doctrine that you would have available to you. So let's just jump in. If we go to the next slide, please. So UCC section 2-615, which has been adopted both by the Pennsylvania legislature and also by New Jersey, as Jared mentioned earlier, it is going to be limited to contracts that are going to be for the sale of goods. And under this statutory defense, if you have a delay in delivery or non-delivery, it's not considered a breach of the contract if either performance has been made impracticable by the occurrence or non-occurrence of an event, which was a basic assumption on which the contract was made, or in order to comply with a governmental regulation or order. Now, this is a fairly high standard. As the slide mentions, just because something's impracticable and commercial and economically difficult aren't necessarily the same thing. An increased cost alone isn't going to justify invoking this UCC defense. Similarly, a rise or collapse in the market isn't going to be sufficient. What this defense really looks for is there an unforeseen contingency? And one of the comments to the UCC gives really a good example of what this means. It talks about how a shortage in raw materials that may be due to a war, embargo, a crop failure, or a shutdown. That's the type of unforeseen contingency that would justify invoking this particular provision. And then obviously, the inclusion of a shutdown makes this very relevant to a lot of, the commercial difficulties that Jared had mentioned at the top of the program. A couple practical considerations for invoking this defense is that if a seller's capacity is only partially affected, they do have to make an effort to allocate among customers in both a fair and reasonable manner. And there's also a notification requirement that if there's going to be a delay or some sort of allocation, which is going to affect full performance, you must notify the buyers in a seasonable manner. So next slide. So this is the common law defense of impracticability or impossibility, which can be referred to either or, again, depending on your jurisdiction. It's a little bit similar to the UCC, but obviously it's not limited just to contracts for the sale of goods. And this doctrine really focuses on whether there was an unexpected intervening event that the parties assumed would not occur. And so we have up there, the three prongs that you need to establish if you want to invoke this defense of impracticability or impossibility. First, there has to be a contingency, the non-occurrence of which was a basic assumption of the underlying contract. Two, the risks associated with the contingency must not have been assigned to either party. And three, the promisor must not have been responsible for the difficulties in the performance. And I'll also add that some jurisdictions will also have sort of a fourth prong to invoking this defense, and that will require that the circumstances which makes the performance impossible must not have been reasonably foreseeable at the time the contract was made. And so I think sort of this is, for me, kind of an interesting point, this foreseeability issue, because what happens about contracts that were made sort of in, January, February, early March of this year when we knew COVID-19 was out there and was a problem. It was in certain pockets of the country and foreign countries, but it was before any of the shutdown orders, any of the social distancing requirement, mask mandates. And so, there's actually a case in the Los Angeles Superior Court that we've been tracking, dealt with the cancellation of a music festival. And one of the interesting aspects of that case is actually this concept of foreseeability, because the contracts that issued were entered into in February 6, 2020, which is, again, kind of an interesting date, right? Because we know about COVID, but we just didn't know really exactly how bad and all of the effects of COVID-19. So this concept of foreseeability is an interesting one, and one that I could certainly see, growing in importance as these cases continue to sort of to be filed and to work their way through the various court systems. So if we could go to the next slide, please. Some additional notes about the defense of impracticability and possibility. It is an objective standard. It's not going to be whether or not the parties, subjectively think they can perform, or it's going to be more difficult. It is, the courts will do an analysis of whether or not the contract can be performed, and that's looking at the contract as a whole, not just whether the promisor can perform. It's typically going to require that a party must demonstrate that it has tried all practical alternatives that are available to it to perform. And there's a case from the District of Columbia District Court, which sort of recognizes, just how high that expectation is for parties. The Suez Canal was actually closed, and the shipping company said, well, we're going to invoke the doctrine of impracticability or impossibility. We can't perform. And the district court actually said, well, there were other alternatives that you could have tried, other different routes you could have taken, and you didn't do that, so you don't get to invoke this doctrine. So it is important that, if you're either teeing up this doctrine or trying to defend against that, to look to see whether or not there were alternatives, and if those alternatives, the parties availed themselves of those alternatives. This doctrine is not going to excuse performance simply because performance may be a little more difficult, a little less profitable, a little more expensive. And the example that we have up there is, is thinking about a wedding. And I'm sure this is one that's probably affected a lot of the participants on this call. If a wedding cannot be performed due to a stay-at-home order from a state government, that might be the perfect scenario to invoke this common law doctrine of impracticability and impossibility. So can we go to the next slide, please? So frustration of purpose is, it's kind of the flip side of impracticability and possibility. They go hand in hand. Sometimes you'll see them pled in the alternative and borrowing, pieces from one another because they are very similar. With frustration of purpose, again, you have an intervening or a supervening event. However, that event fundamentally changes the nature of the contract, and the value of the performance is going to be significantly impaired or destroyed under a frustration of purpose defense. And so the difference between the two is that for frustration of purpose, performance is still possible. There's just no reason to perform, because even if you were to perform, because of this event, the value of the contract is non-existent or near non-existent. And so again, we've sort of put up the different prongs, sort of that generally you're going to need to prove to invoke this defense. And again, recognizing that this is going to, vary slightly jurisdiction to jurisdiction. But first, you're going to need to show that the event caused a total or near total destruction of the primary object of the agreement. 2, that both parties understood that the contract would make little sense without that object of the agreement. 3, the event must not be the fault of the party that's evoking the defense. And 4, the non-occurrence of the event was a basic assumption on which the contract was made. So if we go to the next slide. Again, as I mentioned earlier, this truly is a companion role to the doctrine of impracticability and possibility. And again, the difference is, under impossibility and practicability, because of the event, performance is no longer possible. Under frustration of purpose, performance is possible. There's just no reason to perform. And continuing on with our wedding example, consider that the wedding can be performed, albeit at a lower attendance, and you have a hotel block contract that was expecting, hundreds of attendees at this wedding. Like, performance is still possible, but with this reduced attendance, the purpose of the contract's been frustrated. So that might be a situation where the frustration of purpose doctrine is properly invoked. So if we go to the next slide, which is the last common law defense that we wanted to cover, that's illegality and against public policy. And nearly all jurisdictions have these doctrines in some form or another, that they will not enforce a contract that violates a statute or others' law. And courts aren't going to enforce a contract that violates public policy. So these are going to be narrowly applied. They're going to be highly dependent on the nature of the agreement and also on the law or the regulation that you or the party who is against you is going to be claiming makes performance illegal or somehow against public policy. Now, I will say, we've not really seen these sort of raised as kind of an independent defense, but this is certainly one that you'd probably want to consider. Do you plead this again as an alternative for an affirmative defense, or would expect to receive as an alternative affirmative defense? And some of these, the cases that we've seen have actually sort of borrowed from the doctrine of illegality, saying, performance is impossible under the common law impossibility doctrine because it would violate, statutes, ABC, regulation, XYZ. So even if it's not seen necessarily as sort of a standalone defense, elements of it we really see bleed into some of these other common law defenses and even in the force majeure litigation. So with that, I'm going to turn it back to Jared so that we can kind of go over, I think, some of the interesting cases that have either come out of these COVID-19 litigation issues, and then also end with some of the cases that we are watching.
Thanks, Kira. If we go to the next slide, please. So as Kira noted, we've started to see force majeure litigation in the context of COVID-19 pop up across the country. And there have been a number of cases in which we've already seen some decisions on these issues, and we're going to discuss a couple of those today, including one from Illinois and two from Massachusetts. So next slide, please. Now, the first case is a case that was in the U.S. bankruptcy court for the Northern District of Illinois, and it is called In Re Hitz, and a decision that many consider to be one of the first decisions regarding these issues was handed down on June 3rd, 2020. So the background for this case is Hitz was a restaurant group that operated restaurants in and around the Chicago area, including one particular restaurant called Giglio's State Street Tavern. And in February 2019, Hitz executed a 10-year lease for the space where Giglio's was located. About a year later, in July of 2019, Hitz started to simply not pay rent for that location. And the landlord filed an eviction action in state court. Fast forward to February 2020, which again, the important thing here is this is before the pandemic actually was here and you have any of these government orders related to it. In February 2020, Hitz filed for Chapter 11 bankruptcy protection. Next slide, please. And then the pandemic hits, and you have a number of government orders in Illinois, just like across the country, to try to combat it. March 16th, the governor of Illinois entered an executive order that prohibited any on-premises consumption of food or drink. That was followed 4 days later by a stay-at-home order from that governor. And then you'll see, as the screen notes, there were several orders extending those orders essentially until the end of May 2020. Next screen, please. And so the reason force majeure is applicable here is there was a force majeure provision in this particular lease, and the language is up on the screen. Note, as underlined, it shows that one of the specifically enumerated force majeure events in this lease was governmental action or inaction, orders of government or civil or military or naval authorities. So we have arguably a force majeure event that is covered by the language of the contract. But the important thing is, look at the last sentence in this force majeure provision. It says, lack of money shall not be grounds for force majeure. And we had one of the questions as this has been progressing is, Do you see payment obligations excluded from force majeure clauses? And the answer is yes. And this is an example of a type of force majeure clauses where you see this. Also, specifically in a lot of commercial leases, you are going to see language that specifically says failure to pay rent or the payment of rent is not going to be suspended in any way by force majeure. So similar language as to what's in this particular force majeure provision. Next slide, please. So the landlord, as you may recall, filed this initial eviction action in state court. Hitz declares bankruptcy, everything moves to federal court, to the bankruptcy court, and the landlord there files two motions. The first was a motion for relief from the automatic stay. As you know, when a company declares bankruptcy, all litigation against it essentially comes to a standstill, and you need to get approval from the court to be able to file or continue litigation against it. So that's one of the motions. The second motion was a motion pursuant to Bankruptcy Code Section 365D3 that essentially requested that Hitz continue to pay any post-petition rent obligations. So essentially what this bankruptcy provision says is, if you have a lease, once a party invokes bankruptcy or declares bankruptcy, all of the post-petition obligations under that lease, they still have to meet them. So they have to continue to pay rent. So this, again, was a motion seeking for Hitz to continue paying rent after they declared bankruptcy. So next slide. And again, this shows the timeline. And again, there are two events that I think are really important to this analysis, or at least should have been important to this analysis. The first is, remember, we're talking March 16th is the first government order. So when we're talking about force majeure, that's probably the triggering event that it makes the most sense here. But what happened before that? Two events. First, Hitz stopped paying rent back in July 2019. So way before that, they're not paying rent. So already you have performance obligation impairment. And then you have them actually declaring bankruptcy on January 2nd, or I'm sorry, February 24th, again, before the March 16th order. So keep that in mind as we go through. Next slide, please. So Hitz made a couple of force majeure arguments pursuant to that provision. First, it states that, essentially we have a force majeure event here that applies. And the government's order, again, I think, correctly identified what the force majeure event here was. It's the government order prohibiting on-premises consumption at bars and restaurants. And they then tie that specifically back to the contract, and that was a government action or inaction or an order of government pursuant to the contract. And I'll note again, the second CLE code is 30462, 30462. And if we could go to the next slide, please. So in response to this argument, the landlord made a couple of arguments. First, they argued that the pandemic really had not stopped Hitz's ability to issue and deposit checks or negotiable instruments or otherwise tender payment in US currency. So essentially, you could still pay. There is nothing about the pandemic that kept you from paying rent. And that's an argument I think makes a lot of sense, especially in light of the language in the force majeure provision. Second, they go right to that language. They say the force majeure provision specifically says that lack of money is not grounds for force majeure. And finally, they make the argument that you could have obtained a small business administration loan to pay the rent obligations. Next slide, please. Now, the court, again, this is the bankruptcy court, in ruling on these motions, did find that Hitz had an obligation to pay rent from March 1st, 2020 onward, pursuant to Section 365 of the Bankruptcy Code. But nonetheless, the court found that these government orders that we had already talked about did prevent that performance, at least in part. The court specifically found that the force majeure provision applied to the rent payments after March 16th. Again, that was the date of the first government order prohibiting on-premises consumption. And the court found that that is exactly the type of government action or the issuance of an order that was contemplated by the force majeure provision. Next slide, please. Now, here's where it gets a little funny in that even though the court found that the force majeure provision applied, the court decided to kind of split the baby in a way. The court found that the government order at issue only prohibited on-premises consumption of food, but it did not prohibit carry-out or curbside pickup or delivery. And it found that Hitz simply just did not take advantage of that. They essentially shut their restaurant down. But the court found that it would be fair to only excuse the obligation to pay 3/4 of the rent, because it came up with this arbitrary number of, you could have made 25% of the rent by doing these things like curbside pickup and carry out and things like that. And no basis in the contract to do that. My personal thought is this is sometimes what bankruptcy courts do. They do whatever they can to reach a result that they think is fair. And I think that's what we're seeing in this case. Next slide, please. So everyone is wondering about this. How do you get around the language that lack of money is not a force majeure event? And the fact that the obligation to pay rent and Hitz essentially stopped paying rent way before the pandemic actually occurred. The court, again, as I said, I think they tried to reach an equitable result here, which a bankruptcy court can do. I don't know that you should read this opinion much wider than the specific facts at issue here, but it does go to show that even if you have language that you think as the party on the other side, the landlord here, that Hitz is dead in the water, you never know what a court's going to do with this. And this is a perfect example of the uncertainty that surrounds these types of issues, specifically COVID-19 and its resulting effects, and a force majeure analysis. Do I think this is the right decision? Probably not, given the language, but the court did. And this case has gotten a lot of publication as a result of that. So keep in mind, again, the facts matter. I don't know that they mattered as much here, but as Kira will explain in the next two cases, they really do. And I think the next two cases are going to be more representative of what we can expect to see from courts. But this is a case that's out there. And we wanted to make you aware of it. So with that, I'll turn it over to Kira for the last two cases.
Great. And if we could go to the next slide, please. So we're going to go to two cases that came out of Massachusetts. The first is Future Street Limited versus Big Belly Solar LLC. And this is one that Big Belly Solar manufactured the fancy recycling bins that you can see up on the screen. And Future Street was the distributor of these fancy smart recycling bins. And they enter into a licensing agreement and back in April of 2018. And these dates are important because, as Jared has mentioned, and if we could drive one theme home, the facts really do matter. So they enter in this licensing agreement. All's going well until April 2019. And again, we're well before the pandemic has taken any sort of effect. And for the first time, Future Street starts to raise issues about the products that are being manufactured by Big Belly, saying, these just aren't up to the standards. We're having a lot of defects. We have issues with the products that you're providing us. And this eventually leads to Future Street withholding payment because of the defective products that they alleged that they received. So Big Belly terminates the licensing agreement, which leads Future Street, the distributor again, to sue. And if we could go to the next slide, please. One of the arguments that Future Street brought up is that they said, well, listen, we didn't have to accept these recycling bins, and we didn't have to conform with the other requirements under this contract because our contract has a force majeure provision. And we have the force majeure provision, stated up for their verbatim on the screen. And so they tried to say, listen, we don't have any obligations to perform because it's April 2020. We have a force majeure provision. So next slide. So the court, though, sort of the flip side of the in re Hitz. So the court assumed, by the way, that COVID-19 and its related effects constituted a force majeure event. That was not sort of the main focus on this case of whether or not a force majeure event had been sufficiently pled. The court said, okay, we're going to assume arguendo that a force majeure event occurred. But even with that assumption, the court found that Future Street had acted in a manner that was inconsistent with contractual performance both before and after the outbreak. Now, recall that a year before COVID-19 and the related effects had occurred, Future Street had started to say, well, performance isn't required under their contract because you're providing us with defective goods that we're not obligated to keep. And beyond that, they actually talked about how Future Street, even after the pandemic had occurred, Future Street had continued to accept certain products. They had continued to make certain payments, paid certain bills, accepted certain shipments, all without issues. So to the facts mattering, the conduct was inconsistent with saying a force majeure event had occurred and that performance should be excused. And as a result, the court rejected Future Street's argument that the force majeure event precluded its performance. So if we go to the next slide, these are some of the takeaways which we went over. The facts really do matter. And it also, you have to make sure that if you're going to want to invoke a force majeure clause, to make sure that the actions, the communications, to Jared's point earlier about the evidence that's being created, make sure that this is going to be consistent, because what happened here is that all of the evidence had said you didn't invoke force majeure because there was an actual force majeure event. You invoked it because the timing was right and this seemed convenient. The court really did look at the facts in a more holistic approach. So if we could go to the next slide, please. This is the second case that we wanted to focus on. And again, it's out of Massachusetts. This action started as a partition of real property. And at an auction, Christopher Martorella won the auction and immediately signed a purchase and sale agreement. And so we included up there a couple of the provisions which are important for this matter. It talks about how the purchase price is to be paid at the time of the delivery of the deed. Paragraph 7 discussed when the parties would deliver that deed, and it has that kind of all-important language that we talked about earlier, that time is of the essence for this agreement. Paragraph 20 of the agreement actually said that the agreement contains no contingencies affecting Mr. Martorella's obligation to perform, and equally important, there was no financing contingency in this purchase and sale agreement. So if we go to the next slide. The problem was, at the time of the auction, Mr. Martorella did not have the money to purchase the property that he had just won. And he actually ended up having some difficulties in procuring this financing, allegedly because of the COVID-19 related effects. There was claims that the turbulence in the financial markets caused by the spreading coronavirus created difficulties with completing the appraisal, which caused difficulties with obtaining the financing. And ultimately, Mr. Martorella's business partner qualified for a mortgage with Mr. Martorella's wife. And it's a weird financing arrangement, probably not one that any lawyers on this call are going to ever want to suggest, but we'll just set aside how weird it is that a business partner and his wife obtain a mortgage for this property. So everything's looking like it's going good. They have the financing, those 2 extensions, they gave them enough time to get the financing in place. However, unfortunately, in late March, Mrs. Martorella contracted a very severe case of closing. And as a result, severe case of COVID. And as a result of the COVID, she could not attend the closing. And so the commissioner who was conducting this partition of sale refused to postpone the closing unless Mr. Martorella agreed to increase his deposit, which he refused to do. And ultimately, he chose to file a complaint to restrain the commissioner from selling the property if the closing did not take place as scheduled. So if we go to the next slide. The complaint sought to excuse performance under the doctrine of contractual impossibility. And so this isn't a force majeure case. This is one of the common law defenses that we went over earlier. And the court found that the complaint had not stated a claim for relief. It noted that the agreement had addressed financing and that the parties had actually allocated this risk, saying that there would be no contingencies affecting Mr. Martirella's ability to perform. It noted that Mrs. Martirella, the person who actually contracted COVID, wasn't actually a party to the purchase and sale agreement. And they also, what I thought was interesting, looked at the other types of statutes that the legislature had passed, the other relief bills that they had passed, and said, listen, this type of contract wasn't one of the contracts that our legislature had addressed, so we don't think that we can and should excuse performance. So if we'll go to the next slide for some of the takeaways from this case. The court recognized that this was a harsh result, but they ultimately said this is consistent with Massachusetts precedent, which is what we're going to apply. Again, the facts really do matter. If Mr. Martirella had been the one who contracted COVID, or if his wife had been on the purchase and sale agreement, I think you may have seen that the outcome would be different. And you also have to take into consideration that they had given him a couple of extensions for financing difficulties caused by COVID. So the facts really do matter in any given case. And then the last kind of takeaway from this is don't contract away the potential applicability of the doctrine of contractual impossibility, or flip side, if you don't want somebody asserting this against you, maybe do include these types of contingencies. But the fact that there was a no financing contingency, and it expressly said that there are no contingencies affecting Mr. Martirella's obligation to perform, the court said, listen, this clearly shows that the parties had allocated the risk in a certain way, and the court wasn't going to step in and rewrite or apply the contract differently than what the parties intended. So with that, and we'll go to the next slide, I know that we are short on time, but we've highlighted a couple of other cases that we are watching. And I know that somebody asked about the final code. I think we are coming up to that, right, Jared? Do we have a final code?
I think it was only the two.
Okay, so it's only the two codes, but
yeah.
These are some of the cases that we're watching, including one that's actually a Pennsylvania case and deals, it's a force majeure as applied to a build out in a lease, and whether changing the dates of that, can be excused or changed under force majeure. And, some of these other cases are also really interesting. So we are going to provide, again, the link to jump on to a follow-up Q&A. And so we're happy to oh, and there it is. We're happy to jump on the Q&A and discuss any of those cases if they are of particular interest. Maybe they're in the footprint that you and your companies are interested in. I know that we also had a few Q&A questions from earlier that we either just didn't have time to get to, or because we were a little slow with reviewing. So we're happy to address those, and any other questions or concerns that people wanted to jump in with.
All right, with that will conclude our webinar for today. As Kira mentioned, we are going to be hosting this optional Q&A discussion right after this Zoom. So the information's up on your screen. We appreciate everybody's time today, and we hope you learned something, and we hope you can join us later on today. Thank you very much. Take care.
And Jared or Mary Chris, if someone, we did have a couple of requests to repeat some of the codes. So if we could, for the CLE credit codes.
Sure, I'm happy to help you with that. The first code was 49185. The second code was 30462.
Great, thank you so much. And again, we look forward to anyone who's able to stay on for some additional force majeure and related defenses Q&A.
Thanks, everyone.